Good afternoon, everyone. A quick reminder, the meeting is being recorded. We're going to wait a few seconds to get everyone in the room. I believe, oh, here she is. All right, folks, good afternoon. It is October 25th at 3:01. This is the first meeting of the Legal Issues and Land Review Subcommittee meeting. A reminder that this meeting is being recorded and will be posted on the project website. Let's first go around the room and do some introductions. I'll call on you in the order I see you on my screen. Vance.
Vance Crony, County Counsel.
Jeff.
Jeff Condit, Northern Ash, legal counsel for Coffin Butte Landfill.
Greg.
Greg Verrett, Benton County Community Development. I'm the Deputy Director.
Liz.
Liz Irish, Planning Commission and Benton County Talks Trash Work Group.
Marge.
Marge Marge Pop, member of the work group and member of SWAC.
Holly.
Holly Doyle, in-house counsel with the Republic.
Camille.
Camille Hall, member of the public.
And Pam.
Pam Vaughn, City of Corvallis. I work at Public Works and basically here as an observer. Thank you.
Welcome to all of you. My name is Sam Imperati. I'm the overall process facilitator. Today, I see Darren has joined us. Darren.
Hey, good afternoon, everybody. And thanks, Sam. Darren Nichols, Benton County Community Development Director.
Welcome all. Again, Sam Imperati, the process facilitator. Greg Verrett and I will be tag teaming facilitation of this meeting. So let's go over the ground rules. Here is that we will give a brief opportunity for a public comment period, but basically any observers are free to use the chat to convey any information to the subcommittee. While I don't anticipate a dialogue back and forth between the observers and the members of the subcommittee, I want you to have an opportunity to put your questions, comments, or concerns in the chat. The purpose for this meeting are multifold. One, just to stand up the committee. Two, get you all to know one another. Three, go over the charge of this particular subcommittee. Four, start the substantive discussions with an eye towards clearly identifying the specific questions that y'all might want answered. Six, appointing two spokespeople from the committee who will lead, along with Greg, the work group in a subcommittee report this coming Thursday, basically telling them what we have had an opportunity to accomplish so far, getting any feedback from them on the questions you are working on whatsoever. And that will be the agenda for today. Any questions, comments, or additional suggestions for today's agenda? So let me turn it over to Greg, because he has been the task person assigned to take all the information that's been on the website. He, working with Daniel Reddick, have created a legal subcommittee page that's on the website. And he has a document that he can share with us and walk us through to get an overview of what this document says. And then we'll go about the next steps, which is identifying clearly what are the issues going forward. So Greg, take it away.
All right. So I haven't checked the website, but I will do so. And hopefully can direct everyone to the right document. Sorry, it's been back-to-back meetings today. Okay, so on our Talks Trash website, under subcommittees, the legal A3, the legal issues subcommittee. Okay. Let me see. Sorry, I am Sam. I'm sorry. I'm looking at the website for the first time since this morning. I don't see that document up here unless I'm missing it.
Well, there's a document that you sent out this morning at 10:15. You can use that as the document. I don't know what's been posted since this morning either. Same reason, I've been in nonstop meetings as well.
Okay. And I will open that document. So Sam, as an initial draft, initial final draft, I sent it to you and Darren. I don't know if it's been sent on or if that automatically sent it on to the rest of the group. So if we're wanting folks to have the actual document, I can forward it on to people, or just share it on my screen, whatever would be the.
Why don't we start by sharing it on the screen, and then you can forward that on to everybody so they have the ability to print out a hard copy and access it on their device as well.
Okay. One moment, please,
while he's doing that, I will say that what happened once the charge was approved by the Board of Commissioners, which included a series of legal questions and legal related questions and process questions. Read here charge B of the various charges the board put forward. Staff did several initial drafts of that, and they were sent out early on in the process and have not been looked at carefully since then. It's now time to get them all in one place and reconfirm the two charges. Charge A, which are some common understandings, and charge B, which is land use review tasks. And what Greg did today is take all those various documents that are on the website and put it into one document. And he will, while I'm walking you through this, will email that to everyone. But basically what you see here on your screen are the summaries of what the charter says are the contents of charge A, and there's two issues there: county's rights and obligations through public services, vice versa. Summary.
I'm sorry. The windows are not cooperating. Apologies. Continue on, Sam. I'll get the right thing
Um,
up.
and the summary of the rights and obligations of other entities. Read here, any federal overlay, tribal, state, for instance, DEQ in particular, local government, and what have you. And then there seems to have been confusion when I did the assessment as to the cross-jurisdictional timelines and approvals. You know, what permit, what application, what process goes first before all this is finalized. And a lot of this is by way of creating a document so the general public and newer SWAC, DSAC, Planning Commission members can understand the complete journey from conceiving the idea through either approval, denial, and subsequent appeals. Then charge B, which is towards the bottom of that page, in the assessment, it was clear that there were several terms that were described as unclear, and I understand that pristine clarity is A, not achievable, and B, perhaps not even desirable because of the discretion and flexibility of these terms based on the facts of these cases. But I heard several people say, you know, including the board, can you give us some more guidance or make a recommendation as to where can we look at, or what is the current state of the law with regard to those various terms? And so that in a nutshell is the charge of this work group, is to put together a consensus-based document that is not an advocacy piece, but what I'm calling a law 101 piece, so that folks have a guide to look through to A, educate folks, and B, make a recommendation at a minimum as to where people can look to and help guidance on the various terms. The other overlay of this was there were communications early on between the work group about, you know, to what extent, if any, does or should or can LUBA and the court systems defer to a local jurisdiction's interpretation of its own code and regulations here. And we colloquially called that the deference memo that Vance Croney put out and was distributed a couple of meetings ago. And then we received information from Jeff Condon that appeared in a common understandings document. And so what we have before us today is the first shot of integrating all of those documents. So let me pause there and see if there's any questions about the overall purpose of this. And then I'm going to suggest we dive into talking about what these particular things look like now and need to look like for purposes of getting them in a place where they can be presented to the work group for comment, education, and ultimately possible inclusion in the work group's final report and any kind of public education process that the county decides to do. This is where someone says something like, Sam, thank God you stopped talking. We'd love to comment now and share our points of view. Or words to that effect. So I'm sensing that all made sense. And if it didn't as we go along, you can jump in. So let's start with charge A, question 1, a summary of the county's current rights and obligations and vice versa. This involves the hauling franchise, the landfill, CUP, and what legally can and cannot be conditions of any land use approval. So Greg, there is a portion of this document where there's been a first draft of that. If you could scroll to that, please, and we'll give the folks an overview of it.
I'm gonna hide the white space.
Okay.
So this is where that starts. And so this table was created, I think, as Sam said, a little while back. And then, so I'm scrolling through it, landfill rights and obligations. And then on September 30th, a document or memo from Republic Services that commented on this portion, commented on various elements. This is the portion of that memo that commented, as best I could tell, on the landfill rights and obligations. And then there's a second section on collection rights and obligations. And similarly, a piece from that September 30th Republic Services document. Then what legally can and cannot be conditions of any land use approvals. This was directly addressed by Republic Services. And then reporting requirements. Again, a table was prepared, and then Republic Services also addressed this. And I believe these are two separate pieces of information, the table and then Republic Services input. I don't recall exactly who, what the source of the table was originally. And then, so interpretation and deference is included under this topic. If we go back up to the top, it's number 4 here, but in some ways it makes more sense under charge B, the land use review tasks. So we can decide where that makes the most sense for it to be located. But at this point, it's in this section.
All right, so let's go to the top of that chart there, and we'll just take a few as examples. And Vance, were you the initial author of this draft, or was that someone on staff?
I wrote this, so I'm quite familiar with it.
So maybe you can give us the cocktail party overview of your goals and how you arranged it and how it's laid out.
So the objective was to identify rights and obligations set forth in the franchise agreement and, to a lesser extent, Benton County Code Chapter 23. I identified the right or the obligation. That's in the left column. The center column is where that is found and the authority for that assertion, and then any comments relative to that particular right or obligation. It really is pretty straightforward. I candidly, I don't know where there's any disagreement or conflict. I mean, these just come straight out of the franchise agreement and the, like I said, to a lesser extent, Chapter 23. They're pretty much, they are statements of the way things are according to the franchise agreement and the code.
Okay. Jeff, your sense of, have you had a chance to look at this version or the previous version? This is just in a new format, but the previous version was out there for a while. It may not have gotten to you, but it would primarily begin with you, Republic and the county agreeing that items, whatever it is here, 1 through 31 are accurate statements as to that document. And it sounds like this isn't pejorative. It sounds like this is a cut and paste exercise that Vance took in to summarize the highlights and then put the authority there for the link for ease of reference with some comments.
Yeah, I saw the earlier version of this and we didn't disagree with any of this. It's merely where things are in the franchise agreement and what they say. I think we may have had some minor comments on it, but in the main, we agree with it.
Okay. So then the next step would be, and Liz, this would where you would really like to hear from you, is this treatment of these, what we're calling for shorthand, rights and obligations under the franchise agreement, what you think the work group as a whole is looking for? Meaning, is it too much, too little, or just right as far as the level of treatment of these issues?
So just to be clear, I tend to be a little more brief than most of the work group. It's my understanding that there was questions as to whether any of this was clear for everybody to understand. Like they really felt like maybe there was some discrepancies, maybe some things weren't legal, maybe there was need for clarification. But what I just heard was that both Vance and Jeff agree on all of these pieces for the most part, and there is no major confusion on any of these points.
I mean, I think that's a fair statement. I mean, there might be some I dotting and T crossing, but it's pretty darn straightforward.
Yeah, and I'll just jump in, Liz. What I tried to do initially is take verbatim, and you can see in the left-hand column where I've just put quotes around it, the items, so that it's not, Vance paraphrasing. I'm just pulling the words straight from the franchise agreement in an effort to be as objective as possible.
So then is there anything in this language that you can see would cause confusion or misinterpretation or double meanings or anything that can be misread from a legal standpoint when it comes to the agreement between the county and Republic Services or the landfill?
So, Liz, that's an incredibly loaded question. Incredibly loaded.
You're welcome for
Lawyers,
that.
we can always find something to disagree about.
Yes,
But I will say that this the franchise agreement was the result of nearly 2.5 years worth of negotiations. And honestly, and Holly, I think she's listening in, I think every single word was parsed and discussed at some point over that 2.5 years. So as it relates to Benton County and Republic Services, no, there's no real disagreement or misunderstandings. Well, for Benton County's perspective, I won't speak for Jeff, but and the other thing, what I try to do as the county's lawyers, I try not to write in legalese, because the clearer I can be, the better chance that somebody's going to get the meaning the first try. And I think we tried to do that with this franchise agreement.
Okay, so then I'm just going to ask Greg and Sam, am I missing a point here then that we should be covering? Because that's pretty much the gist of what I got from the committee was, are we sure everything's clear? Are we sure everything's legal? Are we following directions? Are we meeting code requirements? It just seemed like people felt there was maybe ambiguity and misunderstanding, and it doesn't seem like that's the case here.
I would
So the way,
say,
go ahead,
sorry,
Greg.
Sam, I would say in this area, I think it's pretty straightforward. I think there are areas that we will get to further down in the document where there's more subjectivity in the language that we're working with.
Okay.
That's my perspective. I don't know. I can't speak for others on the committee, but that's my perspective on it.
Okay, thank you for that.
So, and then let me just raise one other point as it relates to this section. Let's assume that after some polishing, this portion of the document you all present it to the work group and say, here's our collective sense of the rights and obligations. What I believe the work group could start inquiring about are things like, have they been enforced? Or why, and I'm making this up, I mean, why is it only 2 years when it really should be 2 years and 6 months, or whatever the situation might be? They're talking about, in other words, evaluating that document. I don't believe the evaluation is part of our charge, to evaluate whether or not this is, if you will, a good deal, a neutral deal, or a bad deal. It is the deal. That is the deal that is on the table. And then I'll underscore what Greg said. I think when we get to the other sections, there have been comments from the work group that say we shouldn't even be dealing with this at all. And I believe there's been comments saying us doing this is either illegal or improvident or some unhealthy combination thereof. And that was the initial genesis of the deference memo, which we will get to. So I'm suggesting for next steps for this portion of the document is, Jeff, that you and your team track, change any nuances in it and send it to everybody. And then hopefully we can just get that completed and reconciled either in between our subcommittee meetings or at the next one. Is that fair?
So you're talking about the franchise agreement portion.
Yeah, these items 1 through 31, I believe it is.
Yes, we can do that.
Okay. All right, Greg, let's go down to, in other words, so like this comment you have down here on 9:30, you would just move that up into the document where relevant. In other words, I would like to preserve this table type format, and anything that goes on, that has to go in there. Hopefully there would be a place in one of these rows or a header or something that would put all that together. Okay, so let's go on. What's next here, Greg?
Next is, sorry, the mute button keeps disappearing on me. Next is the collection franchise, collection rights and obligations. It's a similar looking table, suspiciously in the same format. So I'm suspecting that perhaps Mr. Coney was involved.
Well, Greg, my technological scope is very limited.
Hey, it's a nice table. It's a nice table. So between you and Sam, your aversion for spreadsheets is just amazing.
Yeah. The legal documents are done in Word, not Excel, Greg. Please make that perfectly clear. Thou shalt not use Excel. It's illegal to use Excel on a legal document.
Noted. I appreciate the free legal advice.
So same introduction, Vance, I'm assuming for this table, the same process.
Same process. Yeah, I put together the basic components of this as they relate to the hauling franchise agreement. Hauling, Liz, I get it. I use them interchangeably. Collection and hauling depends on the day and how I feel. Same thing. Daniel came and added some elements as they relate to I think DEQ and Benton County Code. No, he didn't do chapter 23. That was me, but he added some elements that were slightly outside of the scope of the franchise agreement. But again, what you see as with the reference to the collection franchise agreement is just what I did with the landfill franchise agreement. I just tried to pull out the rights and obligations verbatim, cite the section, and any comments that are relevant. One of the things that makes the comments a little bit more relevant or beyond just noting the obvious in some cases is there's some history that has gone into the development of the collection franchise over the years. Collection franchise is 10 years, which means there have been several of them over the course of 1 or 2 landfill franchise agreements. And so some of the things change. So I think don't go any further. Greg, I think if you look down there at number 9, the comment, that is an attempt to explain how the rate structure component came about and you can't add all the history into that comment. I did try to give a little bit of context simply because the collection franchise has morphed over the years more than the landfill franchise.
So thinking out loud, not making a recommendation, but seeing if you think it would be helpful, would a simple timeline that has the dates of these things play out with then references to whatever page number, or excuse me, document number or comment number there, be helpful, or just get in the way of an understanding for the person who's not familiar with this stuff?
Well, I guess I would question the value of a timeline, because as things stand, the collection services are governed by the existing collection franchise agreement. So noting that there might have been a change in 1994, it might be kind of interesting, but it really doesn't mean a hill of beans when it comes to what is the status today in 2022 of collection services in Benton County. The other thing, Sam, that's a tall order. That's trying to find a lot of information that not easily found. Over the course of a franchise agreement, things evolve to reflect technological changes, customer demands, Republic's needs that don't always make it into the franchise agreement, but the users, the folks who have the garbage collected, they see. We don't always capture when and why some of those events happen, but they just do. So I understand what you're saying about a timeline, but it could be one of those where you've got huge gaps that, almost beg for more questions than they provide answers.
Can I ask a clarifying question, if I could?
Oh, absolutely. You don't need to ask permission to ask the question. You're a full, complete member.
Are the agreements structured in a way that if something wasn't directly addressed as a change, the previous agreement stands as the rule, that whatever we left alone? Is that how those agreements progress, or are we starting new, fresh from every agreement?
We start new, we start fresh. They have an expiration date, so to speak, kind of like the milk in your refrigerator, and we implement a new agreement that takes the old one's place. So they don't build from each other, they're successively new agreements.
Okay, and so if there were things that were supposed to have been done previously that may or may not have been done, we may or may not be able to prove have been done, is it relevant based on today's agreement then? Oh, I can't hear you, Vance.
Vance,
I was so polite. I turned my mic off while you were talking.
Yeah.
I suppose, Liz, that the answer depends on who you ask. From the county's perspective, we would not be enforcing anything that was supposed to have happened in, say, 2017, but didn't make it into the 2022 agreement. We just wouldn't, because that is irrelevant, as it's not part of the new agreement. I think maybe just to turn your question a little bit sideways, are there elements that were not enforced in the prior agreement that have somehow been captured in a different way? Or are now incorporated into the new one that should be enforced? And that, sure, anything that's in that agreement, we should be looking at and Republic should be complying with.
And I'm gonna, maybe this is a little repetitive, but I would think that you would be looking at those items that weren't enforced in previous agreements if you were aware of them, and maybe make a point of seeing if those still needed to be enforced or put into a new agreement. I'm assuming those are addressed in some way or tracked.
So I'm gonna be brutally honest with you. If something was required, and not just in the collection franchise agreement, but anything Benton County does, and it didn't happen, and it turned out that it not happening was just fine, we're not going to lose any sleep over it.
Okay.
Like I said, I'm just being brutally honest. We just don't have the staff or resources to monitor every little nit and pick of contract, the code, etc. They generally have to, something that isn't happening has to rise to the level where it warrants our attention, it affects the health, safety, well-being of the public. Or, again, let's be candid, we get that squeaky wheel out there that says, hey, Republic is dropping the cans in the bike lane, and they've been doing that, and I can't ride my bike to and from work, then we'll take a look at the agreement and say, are they supposed to be doing that? If so, then we'll contact. So it's kind of a circular answer, and I apologize. It's not as easy as yes or no. If it was, I probably wouldn't have a job.
No, no, I get that. Okay, so it's kind of, if somebody notices and it wasn't dealt with, and somebody says something or brings it to your attention, then you're like, okay, let's deal with this. But we don't have the capacity to follow up on every agreed upon term between the county and Republic Services.
We never have. Daniel is our solid waste expert. Before Daniel, we had Gordon Brown and Bob Wilson out of environmental health. And so that is 1.5 bodies. And even they couldn't keep up with all the nuances of both the landfill franchise and the collection franchise. Just not enough hours in the day and people to pay attention.
Okay.
And I want to clarify, if we get a complaint, we're not just going to take that person's word for it. We'll actually do a little investigating. We'll call Republic, or we might ask somebody who's driving by to take a look. Hey, are those garbage cans actually in the bike path, for example? So when we do follow up on a complaint or an observation that we have of something not happening, we'll do our investigating. We don't take the complainant's complaint as gospel. There's always two sides to every story, so we want to make sure we have the complete story before we decide whether action is warranted.
Liz, you're on mute. Liz.
I have a question for Jeff then, a follow-up question. Jeff, how are you monitoring the agreements? Is there a process that you have, an individual on your follow-through when it comes to renegotiating later and what you promised to do previously?
I would have to go back and talk to the client about that. I'm sure that we do. I think the primary responsibility for compliance is whoever is in charge of the landfill for Republic and or of the Republic Collection Service, and then they would get assistance from staff. But we view it as a contract. We view it as something we have to comply with. And if we get a complaint from the county or from a customer, we investigate it and take care of it.
Okay.
So just as a note for further consideration, I do think that at the beginning of this document, it might be helpful to have a paragraph or two that simply says, as opposed to a timeline, that simply says something like, there have been approximately X number of collection agreements, X number of landfill agreements, and that the most recent ones are the ones that control, and here they are. So for instance, on what we're seeing on the screen here, number 2, board order, is that like the 44th board order of the year 2022? Is that what that number means? So maybe somewhere that if there is a date or something for one of them, so that people can then translate that and keep up with that. But that's like a minor little tweak thing to do. Jeff, following up then, same kind of questions to you. Have you had a chance to vet this section of the document to see if you have any additions, subtractions, corrections? Oh, looks like you did. Okay.
Yeah, and I want to just emphasize, this was the prior version of this, so I have not hadn't had the opportunity to review the amended version, so we want to reserve our rights to do that, which it sounds like we will have.
Well, you're going to have to file a formal motion and
So moved,
order.
Your Honor.
Yeah. Okay, fine. Yes, this is a work in progress. And so, the other piece that I think might come up in the work group are things like maybe a couple paragraphs about Benton County has a collection agreement with Republic. It started on this date and ends on this date. And then the piece about there's a, my word, reopener coming up here that I recall has something to do with what Corvallis is about to do earlier this year. And something that captures that concept. And this could include, to Republic, the ask would be, what other entities do you have hauling agreements with that end up putting the material in Coffin Butte? So you have, I'm making this up, you have one in Lincoln City and it runs till X date. And you have one in, Multnomah County, it runs to Y date. To give folks a more complete picture of this, I'm not asking for an extensive summary of all the terms of those things, but to get that complete picture.
So Sam, I'm gonna push back on your first suggestion of having identifying the reopener. It's already in this document. It's at number 11 right there, and it's quoted verbatim. So, I mean.
Oh, okay. I didn't see it then. I'm sorry. So
right, there we go.
Scroll.
My work here is done.
I see it now. Yeah. Okay, right there. That's fine.
Jeff, I got my homework done. How about you?
Well, I think you need to do mine then too, so. No, I'll have to go back and talk to the client about that. Some of those agreements may be proprietary. It may not be something we can disclose, but to the extent that we can sort of give you a list, we'll try to do that. But I also don't know what, just to echo something that Vance said, I'm not sure how relevant those other agreements are, other than for Republic, we are bound by those other contracts as well, and we have to think about that when we think about planning for the future of the landfill.
Well, so here's how it's going to become relevant based on this morning's subcommittee meeting on landfill size, capacity, duration. There was parallel conversations there that what is the remaining life of the landfill is based upon a bunch of assumptions. One of those assumptions are what are Republic's obligations to bring in waste from other jurisdictions for how long. And as I recall, the Republic, and I'm going to call them engineers, so I'm not sure exactly what their profession of origin is. We're talking about the quote unquote business side as opposed to the quarrying side and the landfill side, that they have these obligations. And so people are going to ask, well, how long do those obligations run? And are you going to be fulfilling those obligations by placing it in Coffin Butte? Because it's going to go to underlying assumptions about how much is going to be brought in between now and effective closure of the landfill. So that's the context or background. All right. So Greg, let's scroll down to the next fun-filled section here. All right, so this is primarily a transition point in the theme of the document. The stuff that we've have so far is, for lack of a better term, the what is portion, what currently exists portion of the relationships going forward. This next portion are questions that came up in the assessment and in some extent, these intent, by way of intent, were incorporated into questions that need to be answered. And so the first one here we have is what legally can and cannot be conditions of any land use approvals. Vance, did you do a piece on this, or Greg? Did we?
I didn't. So I didn't find.
We have a piece.
Sorry, I didn't find a county staff piece that directly addressed this topic. The memo that I prepared dealt with it in some ways, but that was all subsumed under Charge B, and I didn't find anything else other than this from Republic Services. Vance, have you, and Vance's deference memo is down below. Vance, did you prepare anything else on this topic?
I can only do so much in 24 hours, guys. No, I didn't. And actually, I looked at this memo, and yeah, I could add to it, but it pretty much states the way things are. So the answer is no, I did not do anything on this topic.
So the respectful ask then is the reverse of what we've been doing, where the county did a document and Republic is dotting I's and crossing T's. This would be the reverse. We've got this memo as the base, and then Vance, as time permits and the spirit moves you, you can fine tune this and in track change it. And then to the extent we can get agreement, great. And if not, we'll bring it forward to a meeting and eventually give it to the work group to see if they want this included in the report or not.
I do have one question, a direct question that I think has been on a lot of people's minds, and that is whether or not Benton County can restrict who puts what in the landfill. It's my understanding that the state says that we can't limit who uses the landfill. Can we get clarification on that?
Okay, so I did write a memo on this, and I did submit it, and so that can be included. And the answer, Liz, is no. Both the U.S. Supreme Court has said that, and we do not have the authority under our franchise agreement or the Benton County Chapter 23 to limit where the waste comes from. Our effort to at least curb Republic's intake is to put that cap, 1.1 million annual tonnage cap. That was our effort to get to that point.
And so, Greg, do you have that memo in this already, or is that something we'll add?
we'll find-
add between the meetings.
We'll
Great,
find that and add it. Yep. Well done, Vance.
great.
And thanks, Liz, for
And-
bringing up that question. That is key.
Okay, and is there a question below B here, Greg? It's the reporting requirements that comes next. Okay. So who was the author of this document?
I'm not sure.
No,
What is this document? Can you go back
So
to the top there?
so this table of authority and reporting requirement. And it's
I believe that was Daniel.
okay.
Yeah, I
makes
think
sense.
that's right. I think that's right, Vance. I think he did that. And it
then-
looks like Republic has made some comments on it.
Exactly. And I have not compared to see if all of Republic's comments are reflected here or none of them or what, but we'll need to do that.
Well, I'm suggesting that homework goes to Republic
Oh, excellent.
to take these comments that are there and then, incorporate them into the table format, because the goal is to get common understandings. And by definition, in my mind, that means if the county and Republic agree, at least that goes so far. Whether a lawyer or lawyers for the neighbors agree or some other jurisdiction agree is for another day. But it would be one go-to resource for a high-level summary of what the law is there surrounding reporting requirements. And then I anticipate that the work group may well bring up, or the one of the other subcommittees like capacity will bring up, well, where are the annual reports, or the annual reports aren't accessible, or it says it reports this figure, it reports this figure in the annual report, but something on that was reported to DEQ as a different figure. And so how do you reconcile those various numbers? But the starting place for that is to first get us to agree on what are the reporting requirements, and then the subsequent questions can flow from that, depending on the work group and the work group's charge, what have you. So we have a question for or comment. Could we get some clarification on RS comments? I'm sorry, I didn't see the rest of it when off screen. Let me pull it up again. RS is also submitted in an annual report every month. This I'm not sure where you are on that, Pam. Can you? You see something on the screen now that you can take yourself off mute? Section little I.
That's a kind of pasta, sectionini.
Sectionini. Okay. Okay. First
Is-
of all,
I think Pam is
Do
saying
it.
the wording is contradictory. Is that what you're saying, Pam?
oh, right in there. Oregon Department.
Yeah, yes, it seems contradictory. If it's an annual report, that would be annually, but a monthly report is monthly.
So they report monthly to add to the annual report, I'm guessing?
It's a good question.
Okay, well, Jeff, you can figure that out, and and highlight that. All right, we're making good progress. Let's go down to the next section, Greg, please. Okay, so here's what I've called the deference memo. And this has been handed out to the work group. They have seen this. As I recall, Jeff submitted some materials as well, but they seem to be absent right now. So, Greg, on the website, under the common understanding documents from the last meeting, there is a Republic submitted document that's called Common Understandings, and in it, it has several sections, one of which relates to this deference issue.
Yes, I agree. Sorry, I'm jumping around because some of that information. So I took Jeff Condit's memo and inserted it into the elements of Part B or Charge B that it seemed to relate to. And yes, some of it relates to deference, but it also made more sense in some ways to be in Charge B. So I can put it in both places if that makes more sense, or
well, I think
whatever.
what makes sense is to put it in one place and get it refined. And then where it ends up in the final document is just going to be a function of flow or context setting.
Okay.
And so I'm going to suggest, Vance, that you wrote the first memo, Jeff responded, and perhaps you can then look at his and see if all this can be integrated into one memo. It's not necessarily one from you or one from Jeff, but one memo, sort of a law 101 on this topic.
So you, Sam, over the last several weeks, you referenced a Republic memo. I've never seen it. I've not seen it. I know, Greg, you're saying that it's been sort of pulled apart and sprinkled throughout this document, but I haven't seen it. I guess what I would do is I would ask Jeff, if you have read mine, does it need to be refined or expounded upon? I tried to keep it pretty straightforward so that it wasn't either controversial or ambiguous.
Well, there's a simple answer to that, and then there's a more complex answer to that. I'm a lawyer, so here we go. No, I think Vance's memo correctly states where the law is. The question is, as it is applied to an application, and as the interpretation is created, what is plausible and what is not. And, that's not something I think we can define in absence of an application. Part of the reason we're in this process is to determine, what would be part of a new application. I think this is a correct statement, but, I can't commit the argument that my clients may make as a result of a new application, or that the commissioners may interpret as at the time of an application, or that the other side may argue. So we can get to a framework of what the law is, and I agree with Vance's memo, that's what the law is, but then there's the nuances of that in terms of, what's a plausible interpretation in context and what isn't. And I don't think we're going to be able to get a bright line test for people because of that very reason.
So let me frame this up, or attempt to frame this up. I think there are two issues here. One is, isn't this the PGE case from 100,000 years ago, where the Oregon Supreme Court talked about statutory interpretation, and there's these various steps. First you look at the plain meaning, and then you look at something else, and then you look at everyone's astrological sign, and then you look at legislative history, and then you come up with an interpretation. There's that issue. Okay, is to, when you can interpret, and then when you get to the yes, you can interpret because it's ambiguous, then comes the deference piece. They're interrelated, and my recollection of the reading of these two documents is Vance is deference focused, and Jeff is ambiguity focused in the thrust of the memo. And I am simply suggesting that those two memos in some way need to be combined, because if they stand as they are, the average reader will not appreciate the subtleties between those two concepts. Finally, I am not suggesting that there be any interpretation about how this applies in the next CUP, because A, it would be inappropriate, B, it would be impossible because you don't have a fact pattern in front of you to do. So I've never meant to suggest that. If I did, I apologize. That's going way too far. It's just like Law 101. So with that said, who is the best place to take a shot at combining those two topics into one section of this Law 101 memorandum or overall document?
Liz?
I was just about to suggest that it probably involves somebody with a JD after their name.
Junior deity? Junior deity?
Some lawyers think that's what it stands for.
Yeah, that's for sure.
Well, what about this, Jeff? What if I take a shot and send it your way? And then between the two of us, we can come, because there's no dispute about what the law is. So it's really just a question of how do we put this together in a way that's both correct and understandable?
So my only friendly amendment to that last statement, Vance, is that there's no dispute between the two of you as to what the law is. There is confusion or uncertainty amongst folks outside of this particular phone call right now. And in part, this exercise is designed to put forward a clear letter law statement so that people who are interested in learning about this and informing, having it help inform their opinions, will have a place to go to do it, as opposed to just make assumptions. So that's the purpose.
Well, then I think your purpose and what I just laid out align.
Oh, hand in glove.
Okay.
Hand in glove. Hand in glove. All right. So, Greg, can you float down to the rest of this document here? Now, here, just to set up this is the so-called other entities' rights and obligations. So, during the assessment and during some of the work group conversations, there has been dialogue surrounding who regulates what, or whom regulates what, or whatever the proper English is for the term WHO in that setting. Who is responsible for regulating what has had some disagreement out there in the dialogue. The goal of this exercise was to put in one place some of the various issues and give references to the statutory authority, like the one on the screen here, Oregon Revised Statute, Chapter 459, 248. The goal here is to explain who has other obligations, and then explain the interplay between does Republic on the next CUP go to the county first, the DEQ first, both of them simultaneously? And what is the critical path flow between any governmental entity that has to weigh in, permission, whatever it is, to do whatever Republic wants to do? That's the goal of this exercise. Was this a Daniel? I think this might have been a Daniel too. A Daniel also exercise, which maybe we should turn him in for the unauthorized practice of law here, because there are legal terms being used, statutes and things. Let's start off with Vance. You probably haven't had a chance to look at this either, have you? Or have you?
I've looked at it. I mean, Daniel drafted this, what, a month and a half ago. Yeah, I've looked at it a couple of times, yes.
Okay. And does it need any work from your perspective? Any additional additions or subtractions?
There are, I think, some questions put forward in his document, and I'm certain that they have come out of a couple of work group sessions that honestly, I don't know if there's going to be any answers to. So I think it's pretty thorough. And if the objective is, well, let me just back up a half step. This sets out the rights and obligations. It sets out who's responsible, and it sets out the authority for those obligations. And this document does that. This document isn't going to convince people who don't want to be convinced of a certain thing or have an idea of how something might or should work, despite what a statute or an OAR says. So from my perspective, the objective for Daniel was to list the rights and obligations of the responsible entity and the authority behind that. He has done that. I don't have any qualms with it.
I will point out there's at least one hanging question. So, for example, this one doesn't have an answer to it, and it's possibly more of a subjective question than a legal question.
Well, there's just, let me talk about this a little bit here. So there's two questions here. One is a matter of law and one is a matter of policy. This document is not designed to give legal opinions on policy. Yeah, I think so. I would reframe this question, and it will come up, and I do think people should take a look at answering this. It's, can the county legally consider? That's the question, not the should part of it. Is there a law on to what extent, if any, and when can the county consider the existence and or terms in compliance therewith with any DEQ permit? That is the discussion point that has been going on. It's not the goal to try to convince somebody one way or the other. It's simply to have at least a statement that the law generally is this. And it may well be answered pretty simply by saying, well, DEQ is not going to take up its permit until they get a land use decision from the county. So even if it was legal and even if the county wanted to consider what goes into the DEQ permit temporarily, it can't happen.
So I'll talk first here, but I really want to hear Jeff's perspective from Republic. But we do this all the time. we take into consideration state agency permitting topics all the time. The classic example is ODOT. We'll grant a conditional use permit, and one of the conditions is they'll obtain a permit from ODOT for a driveway permit on Highway 20. So we take into consideration the state regulatory authority. We do not usurp that authority, but we blend into, as conditions of approval, compliance with the state entity's permitting or regulatory criteria, and we leave it to the state to do its enforcement and regulation. We don't have the authority to enforce, nor do we have the resources and the staff to enforce, which is why we use the conditional use process to put in place conditions that recognize the authority of another entity, and then we incorporate that into the approval. Is that accurately stated, Greg?
Yep, good examples.
Jeff, thoughts on this topic?
I agree with Vance. I mean, both entities have separate regulatory authority, and if you and there's some preemption language in terms of what local governments can regulate in the DEQ statute. We pointed that out elsewhere. But what has historically been, and DEQ has said, and this was the case with the first application that we submitted in 21, that it will not review the permitting requirements until Benton County has made a land use decision. And so the way Benton County enforces that, and if you go back and look at the permits back since time began, which I have done, that's unfortunately for my client. And that is how the county has done it. They've said, and you have to get a permit. We're approving this subject to these conditions, and one of the conditions is that you have to get and comply with the permit from DEQ on these other topics. And that is because there is a coordination requirement in the state statute between the local governments and the state agencies, and so that's how they set up the coordination. And it also gives Benton County the authority to revoke the conditional use permit if DEQ finds us in violation of one of those requirements. So it's sort of a mutual assured regulation there, but Benton County regulates the land use part of it, and DEQ regulates the environmental part.
Okay, so pause right there. That last 7-minute conversation is exactly what I think needs to be translated into plain text and put in that missing box here.
I was going
It
to
is
concur with you, Sam. That should be somewhere along there. It should be something to the order that Jeff and Vance say they already take this into consideration, right? The county already does take it into consideration, or
right.
the public service takes it into consideration when making their application.
So to put a bow on that, it is one, DEQ has preemption language. Two, the enforcement stick is in the form of conditions, the land use conditions. And if that just is made clear with citations to the relevant, sections of it, that is going to help create a baseline understanding, of the law at a basic level. What I know is below this question, in addition to what we just discussed, what is below this question that should be addressed if there's some bright line guidance is something like this. Let's see if I can make something up here. And please don't fight the example. It's just to give something. My understanding is that DEQ, one of the things they regulate is water quality, and something like that. The author or authors of this inquiry were basically saying, well, and let's say the standard is leachate cannot exceed 5 parts per million. The question is, well, can Benton County say it can't be beyond 2 parts per million? In other words, a more strenuous standard for the reduction of whatever toxic material is. That's in part what this is getting at in this conversation. And that to me gets to the preemption issue, if I'm tracking correctly. So I'm seeing head nods.
Yeah, Sam, I heard that throughout the conditional use process. And so having a clear answer to that question from statute would be really helpful.
Right? And this comes up in many, many ways. You know, it comes up in ODOT, you know, saying that, you know, roads have to be designed to a certain thickness or width or, you know, signage and control devices, what have you. Air quality issues. I don't know if Fish and Wildlife come in. Is there any federal overlay here? We spent some time talking about state. Is there, oh, I see we have ODF down there, and that's where we get the, Greg, can you scroll down a little bit so we can see the ODF and DSL? And yeah, so those boxes, I would hope that we can get some base information there to answer all of those, any questions there with a citation and a comment if necessary. So who's going to take the first shot or divide up these questions? Especially the ones, there's 2 parts: making sure it's accurate, B, filling in the blanks on the missing boxes for open questions. This is the audience participation portion of the discussion. I've seen that work where I ask a question and.
Hello, Sam, this is Jeff. I think, and I apologize, I can't figure out how to work the raise hand icon on my particular.
Oh, okay, no problem.
I think that Republic at least has already submitted some comments about this in addition to some of the comments that are in here. And I think Greg has captured those after the fact. So, you know, I'm happy to go back and take a look at them again, particularly in the context of any new comments that we've had. But some of these issues are really complex, and I'm not sure you're going to be able to fit them in a box. So, you know, the Clean Air Act and the Clean Water Act control, DEQ regulates those 2 entities on a state basis. Same thing with DSL for wetlands. And there's some overlapping jurisdiction, like for DEQ regulates the impact on endangered species through ODFW, requiring us to get permits from ODFW. So it's a really complicated, interrelated series of questions that I'm not sure we're going to be able to fit in a box and make clear that way.
So if the issue is mechanical, meaning formatting, my suggestion would be to start off within the confines of a box, and it may be as simple as saying the rights and obligations are interwoven and are complex. At the highest level possible, the state of Oregon implements water, air under the Clean Air Act or da, 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 da. And then to the extent there needs to drop a page with a little bit more detail in it as an appendix to this document, that's great. And as long as the general authority is there in the box, second column from the right, that then gives the user the ability to dig deeper into, and oftentimes, some of the best authority, given the intended use of this document, is send them to the Clean Air page of DEQ's website, which then sends them to the Clean Air page of the EPA's website, and there you're going to find Q&A or FAQs rather, with a lot of this information there. Darren.
Hey, thanks, Sam. Just to be clear, I hear you fishing for volunteers, and I hear Mr. Condit respectfully skirting around the issue. When you're asking for someone to draft in this document, you're not asking it for it to be Republic Services work product or Benton County's work product. It's the subcommittee who would review, but you're asking somebody to take the initial step in drafting. Is that correct?
Yeah, just the mechanically getting this document moved along. And if you guys want to negotiate some kind of preamble at the front of this, that, these aren't admissions of law or, statements, statements against legal position or, whatever, that it's designed to be an external facing educational tool.
Okay.
So I do have one question about this, which is, where do these questions come from?
The work group.
The work group? They're from the work group? Okay.
Yeah. Now, Sam, if what I just heard is correct, if we're talking about what DSL's relationship is with obligations for landfills, hauling materials management, what I hear you saying is we're all falling back on the federal agencies, we're all falling back on the state agencies, everybody's answering to somebody else essentially, right? Like there is this kind of hierarchy of who's in charge of what. Can we just say that in the document? Can we say, well, DSL's in charge of wetlands, so in regards to the rights and obligations of DSL in association with landfill, they have to monitor wetlands, they regulate wetlands. Is it as simple as that? Is that what you're looking for?
Yeah, and the one layer down is this all gets back to the question, work group question or theme, which is why can't or why shouldn't the county impose wetland, air quality, water quality, habitat, wildlife regulations or conditions on its own that could be greater, more restrictive on Republic than those that are provided by the entities that have the primary enforcement obligation.
I can address that question on a few of these. For example, wetlands, where the county can protect wetlands in addition to or beyond what the SL does if we have gone through a Goal 5 process to inventory and evaluate wetlands and establish regulatory protections for them. So I can address a couple of these, but there are some that are beyond my area of expertise.
So I think the ask is, if I'm understanding this, so I'm conscious of our time here, and I'll do a quick time check. So we have two little ministerial things to deal with that are important. Is Jeff, maybe you could take the first shot at filling in these boxes and bringing up from your memo what you have below. Greg, you add to that memo the places that you have, and we'll come back to it and see where we're at. There is one question, however, that's key that I don't want us to lose. And Greg, could you go down to the, I believe it was a Republic response, and it's right there. Stop right there. What does the regional landfill designation mean? So again, for context, during the assessment, I heard 100.
Stop. I already addressed that in that memo.
Okay, so if you, I just give you the context, that's controversial. It's the only point I was going to make.
It shouldn't
That
be. It's set out in state statute. It's described in our order back in 1974. So it is in that memo.
Okay, and so I will only tell you that I've heard communications from another state agency that believes, that says they don't know what that designation means. That doesn't mean they should know or shouldn't know, or they're right or wrong. But there is not, from the mediator perspective, if you will, I just want to ensure there's a meeting of the minds as to what this regional landfill designation means or doesn't mean.
Well, that's a little surprising, because the answer is a definition in the administrative rule of what is a regional landfill. And it's
Great.
pretty darn straightforward. So
Okay. Then it might mean then what are the resulting rights and obligations that flow from that? So there are the argument has been made. Well, let me just say, people have made these arguments. Doesn't matter who made them. That in essence, there's some people are saying that Republic has said, be that correct or incorrect, that because it's a regional landfill, by definition, they can bring in garbage from other places. Other people say that regional landfill, it doesn't have, it's a self-defining term, but the results of what happens if you have a regional designation or not is not clear. That's the issue. We don't need to resolve it on this call, but that's how it's framed up.
So I can, like, again, that memo that I put forward describes the definition of what is a regional landfill, and it describes the court cases discussing why landfills cannot limit their intake to just in-state or in-county. So
Yeah.
those two issues should be able to go right to the heart of those two questions.
Great. All right.
Sam?
Because of the time, go ahead, Liz, please.
One quick question, which I meant to ask earlier. Can we restrict what is put into the landfill? Are we allowed, we can't restrict where it comes from, but can the county put restrictions on what we allow into the landfill?
I'm going to defer mostly to Jeff, but I know there are restrictions on hazardous waste and certain types of waste that you're not permitted to put into the landfill, or you can only put in after it's been treated or decontaminated. But I think at that point, I'll turn it over to Jeff, because Republic is much better versed in what it can and cannot put into its landfill.
And so given the time, I'm simply going to suggest that, Greg, you capture that question, because that question came loud and clear, I believe, during the tours at a minimum, and maybe also in a work group meeting, but definitely at the tour that came up. And that is a question we need to add to this list. We don't need to answer it in the 37 seconds we have left. Hopefully I can buy a little of your time just to get two concrete things done. All right. So we've gotten as far as we can. Very good, robust conversation. The next is this charge B work, and this is primarily work that's going to be very important too. We'll have to take it up at the next meeting. I would prefer to have the subcommittee report out be done by one Republic done by Vance and Jeff, with Greg working as support, unless someone else can report out this subgroup's work. But I want it to be, my point is, I just need it to be balanced. I think if just one of you did it, there would be perceptual optics issues. So I don't know what the solution is if one of you doesn't want to do it.
I was going to nominate Liz. She is on top of it.
Me too.
You
It
have
will be very
a third motion, a third to that motion.
Okay, well, it looks like you just got railroaded, Liz, is the answer here. Log rolled. Would you be willing to give the report? Greg will help you write it and summarize. It's basically going to be, here's our charge. Here are the questions we're looking at. Here are the members of our committee. You know, here are our next steps, which I'm about to get to, which is, you know, refining this work in our next 2 meetings.
Liz, I was totally bringing it up as an option. If you're interested in playing that role, you don't need to.
I'm happy to do it. I'm happy, but I will need some assistance. So I'll just bug everybody for my questions. So
Absolutely. And that includes me. Feel free to bug me. All right. What we've done for some of the other subcommittees is throw out this initial idea for our next meeting. We've got a series of these going on, and staff and/or I are on several of them. So we're trying to create some consistency. And if this works for you all, it would be consistent with the other workflows, is that we next meet on the 8th and the 15th, the same time as this meeting. And because our next work group meeting, formal work group after Thursday, is on November 17th. So if we could meet in the afternoon on the 8th and the 15th, understanding there'll be some work in between, that could create a kind of a quasi-standing committee that we have a better chance of staffing. But obviously, it may not work for you, in which case I'll do a doodle poll to find our next 2 meetings. I'd like to have 2 before that meeting.
I can do both those days.
Liz can, Jeff? You're on mute, buddy. You're on mute.
All right, I can do the 8th for sure, just checking the 15th. Yes, I can do, well. So would we start at 3?
Whatever time we start, yes. We started. If you can,
Yeah,
if you need
I
to
can
flex
do that.
that a little.
No, I can
Okay.
do that. I can do that. I'm going to be
Okay.
traveling the early part of the day, but I should be back here in beautiful downtown Portland by 3.
Okay, so I'll send out meeting invites so they can be held on your calendar. I will say, Jeff, that there are teenagers available who will help you with the raised hand feature on your Zoom call and checking your calendar and other things. There's a class that you can take.
Yeah, I need to
help with that.
ask. I need to ask. We have a whole department that I can ask, but I'm a little embarrassed to ask. Where's the hand raise feature on Zoom?
Yeah. All right.
Sometimes it appears and sometimes it
Jeff,
doesn't.
it's under reactions.
It's under
It's
reaction.
under reactions.
Mhm.
Yeah.
If you click.
All right.
Oh, okay. I
Mhm.
don't need to ask our IT people. Thanks very much, Liz.
All right. Last call. Darren.
Sorry, Sam, I was just practicing raising my hand.
Oh my God. I'm gonna put this entire group subcommittee is going in timeout. All right, go forth, do good, avoid evil. We'll see you all soon. Thanks so much.
Thanks, everybody.
Bye-bye. Thank you.
Thanks, folks.